Morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime. This is where we cover some of the most interesting live trials in the country today. And today we are covering one of the biggest cases in the country today. It is the Tex McIver case out of Atlanta. That's right, we're entering into day 2. The case started yesterday. We saw opening statements by both the prosecution and the defense. The prosecution really hammering on the fact that Mr. McIver was intentionally shot his wife, Diane, while in the back seat of a car. Now, the defense is saying that this was all a tragic accident, that they were driving, that he took out his gun, he thought there was a danger from outside, he fell asleep while holding the gun, and the gun accidentally went off. However, the prosecution is saying, no. There were some financial motives here, that Tex McIver had more to gain with Diane dead and therefore intentionally shot her. So we saw the back and forth between the prosecution and the defense in the opening statements. And then a few witnesses were called yesterday. We saw the testimony of Janie Calhoun. She was a friend of the victim. We also learned that she actually dated Tex McIver back in the day. And she was talking a little bit about their relationship and the events after Diane's death. And then we also saw some testimony from people that worked at the same law firm as Tex McIver. Remember, he's a very prominent attorney in Atlanta. And they talked about how his stake in the firm went down. He was an equity partner, went down to an income partner. Basically, the prosecution is trying to show that this guy wasn't making the same kind of money that he was, and he would have maybe had more to gain financially from Diane dead. We're going to talk about that case in a minute, but I do want to let our viewers know one other thing. Oh, before I mention that, we do expect live coverage of the Tex McIver case any moment. We believe they're going to start at 9 a.m. We're keeping a careful feed into the courtroom, and as soon as we have it, we'll make sure to go to it. But before I talk more about the Tex McIver case, I want to let our viewers know you can go to lawandcrime.com today to follow another case that we're covering. It's the James Worley case out of Ohio. Now, this is a very disturbing case, but an important case nonetheless. It's about a 58-year-old man who was charged in the abduction and murder of 20-year-old University of Toledo student Sierra Joggin. She was kidnapped back in July of 2016, and her body was found a few days later in a shallow grave. She suffered from asphyxiation, and there's a strong DNA and cell phone evidence pinpointing Mr. Worley in connection with this crime. And the details of this massacre is really tough to listen to, but it's important nonetheless. So you can go to lawandcrime.com today and you can watch that. We're not going to be streaming that here on the network. Our focus today will be on McIver, but you can go on the on lawandcrime.com to watch that. But right now, let's talk about Tex McIver, and there's a lot to discuss here. So I'm very happy to bring it back with us today. She was here the other day. Is former prosecutor Carissa Kranz. Carissa, great to have you back.
Thank you. Good morning.
Good morning. Now, what I love about the Tex McIver case is you can look at it both ways. We heard the openings, and I want to start right now from the crime scene, okay? So the gun. Now, this gun, it was a .38 caliber revolver, but the prosecution and the defense both looked at it in two different ways. Can you elaborate it for our audience?
Yes. So the prosecution is saying that the gun could have gone off with a 12-pound trigger. And the defense is saying it would have gone off with a 2-pound trigger. And this is key because Mr. McIver had a known sleeping disorder called REM behavior disorder, and that causes sudden jerks and actions. And if it only was 2 pounds, it is very easy for this to go off by accident.
Carissa, stand by. We're going to talk about the gun. We do have a live feed right now in the Tex McIver case. There you see the defendant right there, Tex McIver, waiting for court to start. Carissa, you were saying about the gun.
The gun, in this case, the prosecution has to prove this case beyond any and all reasonable doubt. And when you look at the gun and you look at the fact that it was shot through a plastic bag, there is doubt all over this case. But we don't know. We'll see what happens. There's a lot to learn in testimony. The opening statements are just a roadmap. We have no idea what's going to come into evidence based on what the testimony actually is. And it's very likely that the gun, if you really want to kill your wife, there's lots of ways to do it.
I agree with you. That is definitely a point to make, and I think the defense will harp on that. I think we have a live feed right now. The audio is in the courtroom, so let's listen in.
And his non-math teachers think there's something wrong with him, but that's 3.14159. So if you want to do that, that's okay. At 159, that might perk everyone back up. But happy Pi Day, everyone. Hope you all had a good evening away from us. That builds up a little missing of us, so we're back together again. You hopefully recall that where we left off was with Investigator Jackson. Mr. Rucker was asking her questions. He had not completed his direct examination. So we're going to get her back in here. She'll remain under oath. I'll tell her that in a minute. And then when Mr. Rucker is done, Mr. Harvey may have questions for Investigator Jackson, and we'll keep on moving. Good morning, Investigator Jackson.
Good morning, Your Honor.
Welcome back.
Thank you.
You remain under the oath that you took yesterday.
Yes.
And I'm going to allow Mr. Rucker to pick up where he wants to.
All right. And thank you, Judge. Good morning.
Good morning.
Morning.
And good morning. And good morning, ladies and gentlemen. We show you a series of photographs. Counsel, you have any objections? No. Okay. Your Honor, for the record, this is State's Exhibits number 137, 138, 139, and 140. They're all photographs of the office of Diane McIver.
137 through 140?
Correct.
Okay.
And there being no objection, I would tender them in evidence at this time.
Okay. I heard that. Okay. Got it. Thank you. 137 through 140 are admitted.
Okay. Let me just make sure we can lay a little foundation. Investigator Jackson, can you take a look at those photos and tell the judge and the jury whether or not you recognize and can identify them?
I do.
And what are they?
They're the photos of Ms. McIver's office, her office space.
Now, to help orient the jurors, will you tell them where would you be standing if you took this photograph?
That is the view in the doorway looking into her office.
Okay. And then what is this thing right here in the bottom corner? Right here.
This, the table, it's a table that was in there.
A table?
Yes.
Okay. And then what's behind the table?
Behind the table, the marble top, that's her desk where we were told that where she worked.
Okay. And the hard drive for Diane McIver's work computer, it was located where? Where did you actually physically take it from, if you remember?
From the office, it was still on the desk.
Okay. Now, you were allowed to actually go inside of the main house to use the restroom?
Yes.
Okay. And take a look at stage 14. And you recognize that?
Yes.
And how do you recognize that?
I recognize that. That is the door. So this is the door I actually entered to go in and use the bathroom. And then that, of course, kind of stood out to me.
What do you mean by that?
So this, the replica of the gun, because it was a gun, and kind of walking into it, it kind of caught my attention, and then the little word.
You said what?
We don't call 911.
What does it say exactly?
Oh,
It's already been asked.
Well,
He asked it, she answered.
okay. It says on the screen. Let's move on.
Okay. Did you find that the, how would you describe, well, strike that, let me ask you that question. You said there were two properties, right?
yes.
Okay. Let me show you states 18. Do you recognize that photograph?
I do.
And how do you recognize that photograph?
I recognize it because I was there when it was taken.
And what is it a photograph of?
So the property, the back one, this is actually the second property, what they kind of refer to as the saloon.
Okay. And in between the main property and the saloon, there's a pool?
Yes.
Okay. And were we able to actually go inside the saloon?
Yes.
And how would you describe it?
Okay, so you're watching a live feed right now in the Tex McIver case, and right now on the stand is Investigator Terry Jackson talking about when she took a visit to the Putnam Ranch that was shared by both the defendant and the victim. Again, I'm here with former prosecutor Carissa Kranz. Carissa, what do you make of these photos and what we're hearing about the file cabinets?
Well, first of all, it seems like she is trying to speculate that the file cabinets coulda, woulda, shoulda had had documents that may have been important and circumstantial evidence to prove motive of why Mr. McIver should be found guilty. But as you saw, the judge did jump in and redirect her to stop with any speculation and to focus only on what she saw. So then she focused on finding the file cabinets empty. Just from a point of legal analysis, and if you've been following this case, there's been speculation of a secret will. So it seems to me that she's implying that this secret will may have or coulda, woulda, should have been in these empty file cabinets. But also as a side, these file cabinets are at their ranch, their second home. So I'm not sure it would make sense to even jump to the conclusion that the ranch should have her personal items and paperwork. This is a second home. So, you know, at this point, the state is putting on their case. It's a bunch of circumstantial evidence, which will be weighed by the jury, you know, and at the end of the case, they'll pay attention to all the evidence and the totality of the circumstances and come down with a verdict. But you know, it's important to note that this case must be proved beyond any and all reasonable doubt. And you know, there might be a bunch of circumstantial evidence that could tip the scales to show a preponderance, but we really need to have overwhelming evidence to prove a criminal case of murder.
Let's talk about that when we come back. Let's go back into the courtroom because we have more to talk about. The idea of these charges were upped from involuntary manslaughter and reckless conduct to murder, and we know that they might have had a slam dunk case back then, but now it might not be so great. Also, it should be noted that you just saw the sign that said, "We don't dial 911 outside of the ranch," and the reason that matters is because Tex McIver is being questioned about why the fact he didn't call 911 when he had 2 cell phones in the car after Diane was shot. Really important point. Let's listen back in right now.
On the case at the time.
For the Atlanta Police Department?
For the Atlanta Police Department, yes.
Okay. And so do you recall what date specifically we would have gone to see the vehicle?
I do not.
Okay. Can you tell the jurors who was with you when you went to see the vehicle?
So the first time we went to see the vehicle out at City of Atlanta, it was me, Mr. Rucker, Linda Donikoski, Rico. He is also an employee of Fulton County District Attorney's Office. Please forgive me, I do not know his last name. But he's kind of the IT person. Detective Smith met us there. And witness Miss Danny Joe. May I refer to my notes?
Yes.
Her name? Patricia Carter also met us at the property.
Okay. And can you tell the jurors, did you arrange to have Patricia, she's also called Danny Joe sometimes?
Yes, that is kind of her nickname. She's called Danny Joe.
Okay. Did you arrange to have her meet us there at the Atlanta Annex with the vehicle?
Yes.
Okay. And once she got there, can you tell the jurors what happened?
Once she got there, everybody, that was our first time meeting her, introduced ourselves, and she immediately told...
Let's not get into what she told.
Okay.
Unless you're specifically asked, and then we can have the conversation we need to have about that.
Okay. So, Investigator Jackson, you know, I don't want you to say anything that Danny Joe told you or me or anybody else.
Okay.
But let me direct you this way. After we introduced ourselves to Patricia Carter, did myself, you, Linda Donikoski, who's another ADA,
yes,
and Detective Smith have a conversation?
Yes.
Okay. After the conversation, did we go to the vehicle?
Yes.
And can you tell the jurors when we got to the vehicle what happened? What was done?
It is going to include hearsay recitations by necessity. So I'm going to object to that.
Okay, well, I'm going to let it go forward until you let me know that you think we've gotten there. Because I could see that happening, but I could see it not happening also. So I'm not going to preclude it the way the question was framed.
And you understand, I want you to tell the jurors what was done, what we did, what you saw done, but not what anybody said.
Yes.
Okay.
So when we got to the vehicle, kind of a recreation was done where people were sitting at the time of the incident.
Okay. And can you tell the jurors whether or not, what was the purpose, what was Mr. Rico Dollar doing from our office?
He was videotaping. He was recording it.
Okay. Well, it's in connection to this case.
Sure. As long as the question is clear, not because that could have been interpreted things you wish you had done or something
Right.
like that.
No, that's not right.
Things that other aspects of the work she did in connection with the investigation.
Right.
I'll allow that.
Yeah.
And then you'll need to focus it if the answer is sure, X, Y, and Z.
Sure. You understand what I'm trying to say?
I do.
Okay.
I think so.
Does that summarize pretty much what you did?
Well, I also took custody of the weapon that was reportedly used the incident as well.
Okay. And that's right. And did you document that in your notes?
I did. Yes.
Okay. What page did you document that on?
I believe there should be. I'm sorry. It is actually on the back of page 8.
Okay. Okay. And can you tell the jurors what other physical evidence?
That's Investigator Terry Jackson testifying right now in the Tex McIver case. Carissa, why does it matter for our viewers if you could explain about what she was able to investigate in terms of the coverage, obtaining video coverage of the hospital, the Emory Hospital where Diane was eventually taken?
She seems to just be going to the point of, you know, them coming in. We've heard that when he's come in, he yelled gunshot, gunshot. And I guess she's trying to lend evidence or some kind of visual, circumstantial evidence of what happened that day and who she spoke with, those doctors, to lend credibility of their later testimony. And she also was able to obtain their medical records, which goes to Mr. McIver's point of wanting to go to Emory Hospital because she was a previous patient there and they were familiar with her medical history.
Yeah. Yeah. Well, we're going to listen back in. There's been a ton of hearsay objections in this case. Really, we want to hear what she heard other people say, but we're not quite allowed to.
Right.
Let's turn back into the courtroom and hear what she can testify to.
That you created with respect to the work you did. Some of the interviews that was done, you indicate on your notes they were audio recorded.
Yes. So some of the interviews were extremely long, and it would just be too long for me to type out. So for my reference, I did a quick synopsis, and then I put at the bottom, see recording for complete interview.
Okay. And can you tell the jury what was done with the recordings of those interviews?
Those recordings were downloaded to a thumb drive and placed with the case file.
Okay. And turned over to your chief?
Yes.
Okay. Now, let me ask you this. When you spoke to Janie Calhoun, can you tell the jury, was the interview with Janie Calhoun at Alliance audio recorded?
So, yes and no, if I can explain. Okay. So the restaurant was extremely loud, and so I attempted to record it. However, due to the fact that it was so loud, it didn't record.
Okay. And when you say it was loud, give the jurors some idea for folks who jumped into a car in the morning.
So it it was kind of a crowded morning that morning, and so we were at a table. The tables are kind of pretty close. Within arm's distance, you can basically reach out and touch the person that's sitting next to the table next to you. And so I tried, the recorder was placed on the table, and it was picking up all of the background noise, everything. So it was completely inaudible.
Okay. But on your notes, what did you indicate?
Interview was recorded.
Okay.
Good morning, it's Investigator Jackson, right?
Yes,
That's your proper, the way I should address you, that's your proper position.
that is my, yes, proper position,
That
but
was the position that you had when you were here with Fulton County, correct? Investigator, Chief Investigator?
yes,
I just want to address you in the proper manner with your title, okay?
okay.
All right. I understand that you first got this case somewhere in January of 2016, right?
No, last year, yes, yes, okay.
That's my mistake. As you recall, the incident occurred in September of 2016, right?
Yes,
September, October, November, December, 4 months had gone by. And you got involved in the investigation in January of 2017, correct?
correct.
And let's go back to some of the physical items that you told us about. The physical items that you told us about, for example, the handgun, the gun itself, that had been seized by somebody else and had been held at APD since the time of the seizure, correct?
Yes,
And it had been held at APD since September of 2016, correct?
I would assume so, yes.
When you took over the investigation,
Yes,
you didn't send it to the crime lab.
no,
You didn't know whether or not it had been sent to the crime lab from September of 2016 until January of 2017 when you got on the case.
I do remember, and so it being sent to the crime lab.
Okay, right? While you were there?
While I was at the Fulton County District Attorney's Office?
Yes.
Yes, I don't know what day it was sent to the crime lab, though, is...
So when you got in the case, the firearm was already seized and it had already been sent to the crime lab, correct?
That is,
Already come back,
yes, that is my recollection.
all right? And the,
Yes,
okay, the key to the vehicle was in your office, and that the vehicle is the one that Mr. Rucker asked you about, the expedition that you told us that you were in and that you rode around in, right?
no, I didn't ride around in it.
Okay, well, that you were in, that you've seen.
Yes,
Okay. And you also told us about the office computer, correct?
yes,
And the vehicle itself and where it was located. Those are the,
yes.
you got to say yes.
I'm sorry, yes,
Those are the physical items that you told us about, correct?
yes.
Now, when you attempted to do these interviews that you told us about, what you wanted to do was audio record those, correct?
Yes, I do.
Because it's important to know precisely what people say, correct?
Correct,
Precisely what people say to a particular question, right?
correct,
Because you can't take an answer out of context, right?
correct.
and it has to be within the context of what question was asked, the context that it was asked, and the answer that was given, correct?
Correct.
So one thing that you tried to do was audio record these interviews, right?
Yes.
And when you left, and this is March 31st of 2017, the synopsis that you gave us depended upon a review of the actual recordings, correct? Because it was just a synopsis.
Well, it depended upon the actual recordings as well as my handwritten notes also.
Okay, your handwritten notes? You're
Yes.
talking about these notes?
No.
There are some other notes
Yeah.
that aren't reflected in the synopsis? Are there handwritten notes that aren't reflected in the synopsis?
You mean, what do you mean not reflected? So the handwritten notes are there handwritten notes? Yes. Does that make, okay, yes, there are handwritten notes. The handwritten notes are reflected in the synopsis.
That was.
Okay.
So the answer to the question is yes.
Yes.
The handwritten notes are reflected in the synopsis.
Yes.
It's not something different. It's not something supplemental. It's not something different.
No.
It's not something in addition to this, right?
Right.
Okay. I was a little bit.
All right, you're watching the cross-examination of investigator Terry Jackson in the Tex McIver case out of Atlanta. And now we want to talk about this a little bit. Again, I'm here with former prosecutor Carissa Kranz. Question for you. We're talking about this. Why does it matter under cross-examination what her notes, what her synopsis was like? And we know that she was brought to the case 4 months after the investigation. Why does this matter? What is he trying to get at here?
He's trying to cast doubt on the prosecution's case. This is cross-examination, so they just had the state go forward asking a bunch of questions to bolster her testimony, and now the defense is coming in to cast doubt on that testimony. The notes are relevant because he's trying to find out or probe whether or not there's additional information, supplemental information, conflicting information that could be either excluded from her report or written differently in the report, and I think he's getting to the point of trying to poke holes in the case to try to get those notes to see what they say so we can compare them to make sure that they're actually included and reflected in the actual report that she's talking about now, because he's now bringing into the situation and into the scenario these other notes, these handwritten notes. Well, what handwritten notes? Where are they? Why can't we see them? So that's his job now. We are in cross-examination to start poking holes at the prosecution's witness and at the prosecution's case to cast doubt in this matter. So, I think we can continue to keep listening to him and what he's going to say and how he's going to continue to cast doubt before redirect.
Yeah, and what a wonderful braid he has. Shouldn't we talk about that for a minute? I think that's his signature. He's a very famous attorney here in Atlanta. You have two heavyweight teams, it should be noted. The defense team is made up of a series of attorneys that have represented high-profile people, including entertainers and NFL superstars, while the prosecution has really has a heavyweight team of its own and has convicted some significant people, including a renowned killer in the Atlanta region as well. Very interesting setup. Carissa, while I have you real quick, the number of hearsay objections we've seen, I've covered a lot of cases. This is really difficult for this witness to testify.
Well, okay, so two things there. We're going to be hearing from lots of witnesses. As if you've been following this trial, they are saying close to maybe 90 or more. So it is going to be, with all the investigation and circumstantial evidence that they need to present, a lot of it is relying on what other people may have said. So it's very important that the questions are phrased properly, because there can't be hearsay. It has to be evidence that is admissible into court. And also, just to comment on what you just said about the defense team and the prosecution team, I think that's to be expected in a case like this. When you're talking about such a high-profile media case out of Atlanta, where there was speculation that the trial may have had to even been moved for venue to have a fair trial, I think it makes sense that the state would be putting their most experienced, their most senior, the most credible, hard-working, big-gun prosecutors on the case. And it also would make sense that Mr. McIver, who, is from, even if there's, insinuations that he had no money and that he outspended himself. He definitely had enough money to hire a great defense lawyer and lawyer up, and it makes sense that both sides would have the big guns in this case.
Well, let's see how these big guns do. Let's listen back into the cross-examination of this witness.
The entire time, they weren't moved. The file cabinets themselves weren't moved, right?
You say the entire time.
I'm sorry. To your knowledge, the file cabinets have not been moved since September of 2016.
I don't know. I never asked that.
And they, there were, as I understand it, nothing in those file cabinets?
For what I can recall, yes, they were empty.
If there was something, it was September, October, November, December, that the file cabinets had been there and people, whoever it may have been, had access to those file cabinets, right?
Well, I'm going to object. I think what the investigator has said is that she doesn't know.
I think there's going to be another witness, when Mr. Rucker wasn't able to get further with that, he indicated, you know what, there's a witness in a better position to sort through this. So I think this would call for speculation. Next question.
But just when you got there in January is when you went and got these pictures, right?
Yes.
By that time, there was nothing left in those.
I'm going to object to that question as well. I think it calls for a hearsay. She would learn that through the words of someone else.
Physically, when she got there in January.
Do you know if there was ever anything in the file cabinets?
I didn't ask that.
I understand. I'm asking that question.
Okay.
Other than someone telling you that there used to be things in the file cabinet, do you know that there was ever anything in those filing cabinets?
Other than someone telling me no.
Okay. So we need to go to a different...
Yes, sir. Yeah, we will.
Okay.
That's fine. And when you did that, that was also videotaped and audio taped, correct?
I remember it was videotaped. I'm not sure if it was audio taped, a separate audio. I know there was a video camera, so yes.
Okay. And before you left, did you have an opportunity to review that?
I did not.
Okay. And was that part, did that become part of your files?
No. It became, no, it did not become part of my file, no.
Okay, that's what I was asking.
Okay.
Precisely what
Okay.
I was asking. Then you went over to, you also, I'm going to switch again to Emory, because you told us about just a number of these areas, correct? You had the opportunity to go to Emory.
Yes, that is correct.
And to observe the emergency entrance, correct?
Correct.
And the inside as well, correct? The inside of the emergency entrance where you go in if there is an emergency.
Yes, the door area, yes, but I didn't go back into the treatment area.
Okay, just the outside.
Just the outside and kind of the foyer or the hallway, kind of, yes.
My understanding was that you got a video of the outside, correct?
Correct.
Of the evening of September 25th of 2016.
So I'm not sure if that's I got a video from the evening of the incident. So
That's fine.
Okay, yes.
The outside, but not the inside.
No, the inside as well.
Okay, the inside of
The hall, not the treatment areas, just
Okay.
the hallway.
And that makes sense because they're not going to be videotaping the treatment area.
Correct.
For privacy and other reasons. So let's go back to Ms. Calhoun's statement
Okay.
that wasn't preserved on the audio tape. Is that the only is that the only audio tape that you conducted, or the only interview that you conducted that the audio tape did not record appropriately?
No. So there was another one as well.
Again, you're watching the cross-examination right now of investigator Terry Jackson. She's from the DA's office, and this is the Tex McIver case. Again, I'm here with former prosecutor Carissa Kranz. There was one interesting part where they had a back and forth between the attorneys and the judge about the file cabinets. What was the significance of that in terms of whether they were empty or they were not empty, and what she could testify to in her capacity?
Right. So there was a question, and then there was a hearsay objection, and then there was a speculation about whether or not those file cabinets were empty, and to her knowledge, were always empty. And they were trying to pry into speculation, which is an objection. So the judge then jumped in and asked her directly, which she then looked at counsel to see if she should answer. And then the judge repeated himself and asked again directly, I'm asking you, to your knowledge, other than someone else telling you, have you or do you know from your own knowledge that those file cabinets had anything in it ever? And her answer was no. So that was key. That was key because the file cabinets were found empty. That's all it is. Anything else is speculation of what those file cabinets coulda, woulda, shoulda had.
Well, it's definitely an exciting case, especially between the attorneys. They're going back and forth. They're not letting anything slide. So let's listen in again. We do expect a morning break soon in this case, but let's listen again to investigator Terry Jackson.
At the end, interview was audio recorded, correct?
That is correct.
Okay. And when you put the synopsis here, there was not a date. We don't have a date of the interview, do we?
No.
We don't have a time of the interview, do we?
No.
We don't have a location of the interview. That's just from your memory now, some time later, over a year later, correct?
Correct.
All right. And we know that it is not verbatim. We don't have the context, we don't have the words, and we do not have what actually was said, correct?
Correct.
But we know that Ms. Calhoun said she never witnessed Tex and Diane argue, correct? She told you that they were very much in love and they were the perfect couple, correct?
Yes, that is one of the things she said, yes.
Well, I know there were a lot of things she said, but we don't know exactly what. But we know she said that, right?
Right.
Okay.
Yeah, to be precise, no. So I remember from what I can recall from my memory, we started as we exited off the highway.
What highway?
I went 75.
Going north or south?
Again, I'm trying to recall solely on my memory. I believe we were coming south. Yeah, I believe it was south.
Okay.
I believe.
Let me see if I can, let me ask you this way. Where do we end the route drive? Where do we end it?
Oh, we ended going to the hospital. She directed us to the hospital.
Okay. And before we got to the hospital, where did we stop on 14th Street? What's located in that area?
What do you mean? So
It's 14th Street and what intersection?
14th and I want to say it was Piedmont because we was literally right across from the park.
Right.
When we got out, yes.
Right. Okay. And so before we got to 14th and the park, which way do we go to get there? Did we come from Buckhead or did we come from the other direction?
I believe it was the other direction.
Okay. And do you know how we exited the expressway? If you don't, you don't. When you say we were on the highway, do you know where we got off the highway?
Oh, yes, no.
Okay.
I can't recall.
All right. Let me ask you this. But Chief Wakocha was present for that as well?
Yes.
Okay. And do you know when the case file was actually turned over to our office from the Atlanta Police Department, when you would have started working on it?
The exact date, no. I know it was turned over the end of December, the beginning of January.
Okay. And prior to the case file being turned over to the Fulton County DA's office, did you do any work on the case before that?
No.
Okay. So you never did any work with Darren Smith or helped him or do anything like that?
No.
Okay.
No involvement.
Okay. And finally, while we were at the ranch and we had the opportunity to be there and look at it and walk around, did your investigation ever reveal how much money it takes to run the ranch per month?
Okay.
And Mr. Swank, and that's not even an appropriate question. It's not a legal matter. It had nothing to do with cross-examination.
Okay. So I'm just going to sustain the objection. If you need to ask a different question or maybe a different witness, can work through that with you.
Yes, sir.
All right.
That's all my questions, Judge.
Okay. Any questions from the jurors for Investigator Jackson?
All right, you're watching the conclusion of the investigator Terry Jackson's testimony. And let's not forget, in this case, jurors can ask questions of the witnesses. That's what we're waiting for right there. And right there on your screen is the defendant, Tex McIver. It looks like he's having a conversation with his attorney. Again, I'm here with former prosecutor Carissa Kranz. Do you always see, it's rare to see cases where the jury can ask questions, right?
It's not as common, so it'll be interesting to see what they ask and how the witness handles the questions, and also if there's any objections and what kind of objections they are. We've certainly seen a lot of objections this morning for hearsay and speculation, and the witness being re-instructed to testify only to her knowledge of what she saw and what she knows directly. So this will be an interesting next phase.
Do you think she was an important witness?
I think she was important for the prosecution to help paint a picture of who Mr. McIver is, and to try to build prejudice and to give circumstantial evidence that could lend an opinion for the jury to make their ultimate decision and verdict. She's important for them because she's testifying that the file cabinet was empty, which goes to the speculation, and it is just speculation of a second will. Right now we have no evidence that has come in that a second will or a secret will actually exists. We also have no evidence that that file cabinet ever had documents in it, and it's possible that it never did. This was their second home. But it is important because she's a witness to help paint the picture, and that's what it's all about. I mean, the state puts on their case and they paint a picture about the defendant, and then the jury gets to ask questions and weigh the evidence.
Carissa, I think we have instruction now. Let's listen into the judge.
Great.
I apologize. I need to have those questions.
Sure.
You understand?
Sure.
Thank you.
Yep. You and Mr. Harvey talked about how you use the plural, casings.
Yes.
And there was some discussion about the weapon being tested. Question, do you recall how many shell casings were the byproduct of whatever testing was done?
No.
Right? Mr. Rucker, any follow-up based on that?
No.
Okay. Mr. Harvey? All right. Thank you, Investigator Jackson. You guys okay to press?
Okay, so that witness just exited the stand. We're going to either go to a break, we're going to have to hear what they're going to be doing, or they might be going to another witness. Okay, so the last question that the jury just asked is, do you recall how many shell casings were the byproduct that were done? Like how many shell casings there were? And she said no. Why does that matter when we're talking about this shooting death?
I guess the jury is trying to figure out what casing was actually part of the death and evaluated, and which ones were testers, and why there were so many casings. The jury is trying to make sense of a previous comment she made earlier in testimony when she couldn't recall how many casings there were and how many testings that there were. And there was no follow-up questions by either counsel, so it seems like that was just a question of the jury trying to figure out how many casings may have actually been used that night.
So we're talking about what the evidence in this case, and you talked about a little bit earlier about the second will. Now, from early reports, we can tell that this second will was going to bequeath the property, the Putnam Ranch that we keep hearing about in this case, not to Tex McIver in the event that Diane died, but to her godson. And we heard the testimony from Ms. Calhoun yesterday, and she said that Tex knew about this, knew that the property was going to go to the godson, and he was happy about it. So how important is this second will, if in fact that's what it states?
Well, right. And we still don't know that there is a second will or a secret will. This is just part of painting the picture of who he is and to give circumstantial evidence of why he may or may not be guilty. You know, according to the defense, that property was always going to go to the godson, and he was okay with that. So, but according to the prosecution, that was motive for him to kill her and paint it to be an accident so he didn't stand to lose the property.
Right.
So this is all going to have to be weighed by the jury at the end based on the picture that's painted, and it is going to rely heavily on witness testimony and circumstantial evidence.
The judge is speaking to the attorneys right now. I wonder if we can listen in and we'll come back. All right, Carissa, yeah, we don't have sound in the courtroom right now. Okay, I want to talk to you about the biggest thing that we heard yesterday. It was the very words of the victim. So when she was brought to the hospital, she didn't die immediately upon the gunshot.
No.
It took her about, I think, 4 hours.
Right.
She said to physicians, it was an accident. It was an accident.
Right.
How does the prosecution get past that? That's the victim's own statement.
Well, the prosecution's going to get past it by painting a picture of motive, of financial gain.
But why would she say it then? Why would she say it was an
I
accident?
think the jury needs to listen to that. I think that there is doubt all over this case, and this is going to be a very difficult case to prove beyond any and all reasonable doubt. We have to remember we're in the criminal standard here. It's the criminal burden, and that's a difficult burden to reach. You know, there can't be reasonable doubt. So if she's saying it was an accident, that's the only testimony the jury's ever going to hear from the victim.
The prosecution can turn that around and say, well, okay, she said it was an accident, but they knew, Diane knew that she was going to have a tube put down her throat. She wouldn't be able to speak. They said, do you want to speak to your husband? And she said, no. Now, I could see why the prosecution could turn that and say, oh, I don't want to talk to him, but the other way.
But if they say no, then they're taking that no out of context. And under the rule of completeness, the defense attorney can and should object and say, no, I want the rest of that no phrase included. What did she say after that no?
Well, even if she said no, okay. If you take it to the defense that this was an accident, maybe she didn't want to see the guy that accidentally shot her.
Right, or maybe she was just in so much pain she didn't want to delay the process and she just wanted to get on with the surgery and save her own life and try to fix the situation.
Right.
I do believe she thought it was an accident because she said that on her deathbed. But she also said, no, I don't want to see him, but that no was followed up with context of why, and we're not even thinking about the pain she may have been in.
Now, let's talk about that. So the other way of saying it was an accident, she was in the front passenger seat, Tex was in the back seat. She didn't see what happened before the gunshot. Maybe she thought it was an accident when it was something a little bit more nefarious.
Well, and that's part of the case that's going to have to be put on, and the jury's going to have to weigh the evidence. But I think it's important to, look at the situation. They were in an area that they felt compromised in. She handed him the gun. It was in the plastic bag. He shot it from the plastic bag. It was still in the plastic bag when he shot the gun. It went through the seat. I mean, if he really wanted to kill her, there's other ways to do it.
Exactly. And the plastic bag didn't resonate for me because we all know he's the shooter. The defense conceded he's the shooter.
Correct.
So the fact that the plastic bag contained the gun residue and wouldn't get on his clothes and hands, who cares? We know he was the shooter. What does it matter?
Well, and not only that, shooting through a seat where there's metal in the seat could have caused the gun to ricket and come back and actually shoot him.
Okay.
So there's a whole lot of things that could have gone wrong if he was trying to kill his wife. I mean, the gun could have ricketed back to him. He could have caused an accident because he could have startled the driver. I mean, there are other ways to do it. He also could have taken it out of the bag to shoot it in a way that he could have secured and made sure she was going to die.
Now, I will play devil's advocate here, partly because it's fun.
Okay.
But we had a case called the Todd Kenhammer case, where a guy was in a car with his wife. A flatbed truck came by. He claims that this was all an accident. He said a pipe fell off the flatbed truck, pierced the windshield of the car that he was driving, hit his wife, and she died. He was ultimately convicted. They said that he staged that accident. And the question became, in that case, if you're going to kill your wife, wouldn't you have done it in a less complicated manner? Then the same question comes here. I mean, is that a good standard to judge a case by, that someone might have another way of killing somebody, the easier way?
Every case is different, and every jury is different. And, you know, you and I can sit here and take an analysis of this, and we don't know what was going through his mind that day. It's possible. It's very possible. It doesn't mean it's reasonable, but it's possible that she handed him the gun. He started to think about financial problems and issues, and he just pulled the trigger. And then he freaked out and he panicked, and now he's, you know, trying to cover it up and saying it was an accident. But he may have had a moment of, you know, panic.
We won't know that.
We don't know. The issue is whether we can prove that it was an intentional killing and not an accident beyond any and all reasonable doubt. Spoken
like a good lawyer, I must say. But as we try to understand what happened in that car, something happened earlier in the day today as this witness was testifying. There was a picture that was shown to the jury, and the prosecution kept showing it to the jury. It was outside of the ranch. It's a sign. It says, "We don't dial 911." And there's a little revolver right there. Prosecution kept showing that to the jury. What did they want to paint the picture as for them?
Correct. They kept showing that to the jury. I believe they showed it to the jury around 4 times. That is another picture to paint about Mr. McIver, which, in my opinion, is it's to distract. It's to paint a negative picture. It's to portray a prejudice that he's for guns, he's for shooting, he's for taking matters into his own hands, and he doesn't dial 911. Because in this case, after this killing happened, he didn't dial 911. He took matters into his own hands by driving his wife, or continuing to have the car drive his wife to the hospital and the ER. He picked the hospital. But I think it's a long shot. You know, that's a decorative piece. That's a decorative sign on someone's property. It was a huge ranch. You heard it was over 100 acres. And it is very common on properties to have signs like, "We have dogs," or "You loot, we shoot," or, certain homes, I don't know what the law is in this state, but they have standard ground laws. So if someone enters your property and you feel compromised, you have the right, and it is a justified killing, to shoot and kill. So to me, that's a decorative sign to just say, don't intrude on our property. We won't call 911. We'll take matters into our own hands. But that's, I think...
Don't look at it more than it is.
I don't think it's related at all. I think it is a prosecution's way of trying to paint a negative picture that's prejudicial about Mr. McIver. And, hey, a visual is worth 1,000 words, and they were able to show that visual many times, and you'll probably keep seeing it.
Probably. And we're talking about it. So there you go. If we're talking about it, they're talking about it.
Correct.
But what I want to play for you right now, in case you missed it, was the defense's opening statement from yesterday, and I think her name is Amanda Clark Palmer. She did a terrific job with her opening statement, and the reason was, when you heard the prosecution's opening statement, many people probably heard that and thought, oh, this is an open-shut case. This seems like a man who really did kill his wife. And you heard the defense attorney be very relaxed and pinpoint and really contradict each of the points made by the state. So let's play a little bit of that for you right now.
At that point in time, and I'll get to this a little bit later in more detail, the gun is in Tex's lap, okay? It's kind of laying sideways in his lap. Like this, he's falling asleep. When I get back in my park, the gun just discharges and goes off. And it takes a second for Danny, Joe, and Diane to realize what has happened. I think Danny Jo, I expect that she'll tell you at first she thought maybe somebody hit them in the car. She wasn't exactly sure what the sound was. And Diane says, "Tex, what did you do?" And then a few seconds later, maybe even close to a minute later, it was a traumatic situation. Nobody had a stopwatch. So all these estimates of what happened when are really people just kind of reaching back in their memory during this traumatic point in time. trying to say, here's my best recollection of what I think happened. But some time passed, again, seconds, maybe up to a minute, and Diane starts to kind of, I don't know about writhe in pain. I believe that what Danny Joe said is that she kind of starts to slump over, and she kind of starts to lose consciousness. And so Tex is in the back seat, and he reaches forward, and he wraps his arms around Diane. He's holding her head in his hands, talking to her, trying to kind of figure out what's going on. She's shot, as the state says, she's shot in her kind of mid to lower back. There's not a lot of blood. It's not what her injuries are. There's not kind of blood pouring out everywhere. You're going to see pictures of what the inside of the SUV looks like. You're going to see pictures of what Mrs. McIver looked like at that time. You'll see that there's just very little blood. So they're trying to figure out what happened, how serious this injury is. And Danny Joe says to Tex, "Where should I go?" Maybe she was thinking that Piedmont Hospital was closer, but she never said to Tex, "How do I get to Piedmont? We should go to Piedmont." What she says is, "Where should I?"
That's the beginning part of the defense's opening statement in the Tex McIver case, which is currently in break right now. As soon as we have a live feed, we'll make sure to go back into the courtroom. But we have a lot to discuss right now about this case, including what happened today and yesterday with the defense and prosecution's opening statements. I'm joined on set again by former prosecutor Carissa Kranz. We're seeing the opening parts of the defense's opening statements. I thought she was just doing a pretty good job of that. What did you think? It's interesting. You say two different ways. When you heard the prosecution said that he just shot her deliberately, and here you have a guy, they were in a loving relationship. He was putting his arms around her, even on the outside of the seat after she was shot. I love the way that she characterized it a little bit differently, that it really did look like an accident.
Right. Just listening to that right now and having her explain how he was falling asleep and then the shot went off accidentally and then he reached over and he tried to hold her and keep her head up and talk to her. It definitely lends some sympathy.
Carissa, I'm sorry to interrupt. I'm sorry. I believe we have a live feed back in the courtroom. So stand by. I know we have you for the rest of the morning, but let's listen in about what's happening in court right now.
Can everybody hear me?
We'll see.
Can you all hear? Good morning, Ms. Meadows. How are you?
Fine, thank you.
Could you please let me know where you're from?
I'm from Atlanta, Georgia.
And what neighborhood did you grow up in?
I grew up in Atlanta.
In the city of Atlanta?
Uh-huh.
And where are you currently employed?
I am unemployed at the moment.
And were you previously employed by Corey Enterprises?
Yes, I was.
And what was your job duties at Corey?
I was the receptionist, administrative assistant.
Okay, and how long did you work there?
I worked for a year and a half.
Okay, and when did you start?
July the 5th, 2016.
And what was your last day?
At the end of this past year, 2017.
So December 2017?
Yes.
And before working at Corey, what was your occupation?
I was a homemaker, a stay-at-home mom.
Okay. And how did you come to be employed by Corey Enterprises?
Well, I was looking to return to the workforce, and my neighbor, Danny Joe Carter, saw her in the neighborhood and waved. She says, "Hey, are you looking for employment?" I said, "Yes." And she says, "I think I have a job for you." And it would work for me part-time, 3 days a week. And to look into it and call Mr. Hahn, and I did. And I was hired a month and a half later or something like that.
Okay. And you said you worked part-time?
Yes.
What days of the week did you work?
I worked on Tuesdays, Wednesdays, and Thursdays.
And what hours did you work?
8:30 to 5:30.
Okay. And you said you worked as a secretary?
Well, assistant. I helped in different areas.
Okay. And did you help anyone in particular?
Accounting and with the ad part of the company, with invoices and things like that.
Okay. Who was your direct supervisor?
Shirley. I'm trying to think of the last one. Immediate Angie Brooks.
Okay. And at Corey, at the office, where was your office situated?
I sat at the front desk as you entered the building.
Okay. And were you responsible for letting people in and out of the building?
Yes.
Okay. And how would people enter the building?
Well, you have to go to the call entrance. There's a call phone to enter. There's a gate.
And who would they call? when they
Me.
called?
So it would directly, the phone would ring at my desk. And I had a screen I could see who comes and goes.
And did the employees have to bring in to get inside of the building?
We have a passcode or either a remote.
Okay. And did everybody have the same passcode or were there different passcodes?
They're all the same.
Describe to the jury how he looked to you.
Angry.
Your Honor, objection. You could instruct the witness just to describe his physical characteristics and not give an opinion as to how he appeared.
So, what's your response to that objection?
I mean, I think she can observe how he appears to her. I don't think it requires any type of special knowledge to it.
I'll allow it.
Could you continue, Ms. Meadows?
He was red-faced, the stern look on him, and it's like I've just not seen too many people that look like that. I'm just saying that he
Objection, Your Honor. Now
was
we have moved
red-faced.
on.
When she objects, you guys
Okay,
stop.
she's thinking.
Now we have moved on from describing how he looked to characterizing it, her opinion of how he looked. She said, red-faced, stern look, something like, I haven't seen other people look like that. I asked that the witness limit it to how Mr. McIver appeared physically.
Okay. I'm going to ask you to go on to your next question. I'm going to allow that, but we're done with the description.
Okay. I'm going to show you State's Exhibit number 3. And if you could describe exactly how was he red-faced? If you could show me on there.
But he didn't look like, I mean, his face wasn't like this, but he was just all red. It was just an all ruddy red face.
Okay, like red, like an apple. If you could describe it, how red?
Severely sunburned.
Okay. And you said he appeared to be stern. Compared to this, did he look like this on this picture?
No.
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 Okay. And before you saw him this day, how many times before had you seen him?
Maybe once.
Okay. And did he appear different this time than he did the other time that you saw him?
Yes.
And besides working with at Corey, did you have any type of personal relationship with Diane?
No.
And what about the defendant?
No.
And to your knowledge, was Diane in the office that day?
Yes.
And was Mr. Corey in the office that day?
Yes.
And when you saw the defendant, did you think she was there at that time?
Yes.
Where did you think she was?
Well,
Maybe in
I'm
Mr.
sorry, I object. Are we speculating or are we asking the witness to say something she observed at that time personally?
Right. You're going to need to ask your question in a different way.
When you last saw Diane that day, before the defendant came, where was she?
And you told us that you don't socialize with Mr. and Mrs. McIver.
Right. Correct.
Sounds like maybe the total time you have ever had a chance to personally observe Mr. McIver on these 2 occasions added up to a few minutes.
Well, when he had come into the office prior to that. I've seen him. It was in the front lobby area.
How
So,
long was he in the office that previous time?
You know, I'm not really sure. They were meeting other couples to go to dinner, and they had gathered in there.
Was he there for a brief period of time or something more like 20 or 30 minutes?
I'm not real sure.
Just don't recall.
I don't recall how long they were there.
Okay. So you can't tell this jury that you know what Mr. McIver's normal demeanor is, correct?
Correct.
Okay. Because you don't know him, right?
I don't.
And you told us that he appeared red-faced, as if he was severely. Well, that's what you compared it to.
He was like beet red.
And you compared it to being severely sunburned.
Yes, he was red-faced, just red-faced.
Okay. And you said he had a stern look on his face, right? I'm sorry.
He was not happy.
You have to say yes or no for the court reporter.
Yes.
Okay. You don't know where he was coming from.
No, I don't.
Was he carrying anything in his hands when he came to the office?
No.
Was he carrying anything in his hands when he left the office?
No.
All right. You don't know how he got to the office.
No.
You don't know if there was somebody with him outside the office.
No.
You don't know if there was somebody with him when he left the office, right?
No.
You don't know what other conversations he had had that day, right?
No.
Don't know what else was going on in his life or his work at that moment.
No.
Okay. All you can tell the jury is what you observed in that approximately 90 seconds on Thursday, September 22nd.
Correct. Yes.
All right, thank you.
Ms. Griffin, any follow-up?
Ms. Meadows, why do you remember this particular occasion?
Well, it was just just a sudden thing that normally, you know, the people don't. It was totally unexpected because I screened the door. I watched the video, and I didn't know that people could just come in without my permission or without having an appointment or whatnot. And I was actually taken by surprise with the door opening and hearing it shut and looking up from and seeing someone come in that manner and leaving.
Okay. May I have some brief follow-up just on that one?
Super brief.
Yes, sir.
That was one question.
Yes. With a somewhat lengthy answer. Am I correct that you were surprised because you thought only U.S. Enterprise employees were able to get in and out that door without you buzzing them in?
Yes.
Okay. Thank you.
Any questions from the jury?
All right, everybody, there's a jury question now being proposed for Gail Meadows, who's an administrative assistant at Diane McIver's company. It's going to be interesting to hear what this question might be. And all she really testified to was the fact that Tex McIver, a man she really didn't know, she saw on one other occasion, she saw pictures of him. He came into the office the Thursday before Diane was killed. She said he had a red face, could have been from sunburn. He had a stern look on his face. He was in the office for about 90 seconds. Peeked inside Diane's office, walked past the office, didn't talk to anybody, didn't have anything in his hands, didn't have anything in his hands when he left, and then exited. Now, again, why is this important? Real quick before they go to the question, Carissa, what do you think? Why is that important?
I think they're just the prosecution is trying to lend more circumstantial evidence to show why this might be suspicious. He had never really been to the office before. He was in and out real fast. His demeanor was that of someone that wasn't happy. And they're trying to build a case to show why this may have been a suspicious moment because he's never been there before and you know, I think he got in a back door. She didn't buzz him in. There was, you know, it stood out to her because he wasn't someone that was regularly patroning the office, and it was out of context, and he didn't look happy. So she remembered the moment, and the state wants to memorialize that moment.
Carissa, let's listen in on what the jury question is.
Work at U.S. Enterprises anymore?
Well, after Diane's death, Mr. Corey sold the advertising section of Corey, U.S. Enterprises, and that was a large part of the money that came in for the business. And so he slowly sold off the outdoor billboards in the airport advertisings, and slowly closed them off, sold them. So therefore there was much work for me left to do with correspondence, with invoices and such. And so that's why I'm no longer employed with them.
Okay. And then on the situation you've been asked about you were saying it was on the 22nd, whenever it was, explain to the jurors whether you buzzed, if that's the right term, Mr. McIver in, or if he got in without you buzzing.
He was able to enter the building without my assistance.
Okay. Any follow-up based on that, Ms. Griffin?
No, Your Honor.
Ms. Clark-Palmer?
Just very briefly. Is there a code you can punch in to get in that front door without you having to buzz somebody in?
Yes, sir. You have that, yes.
All right. Let's just say the code is 1234, and I'm not an employee. You could say to me, hey, the code is 1234. I could go punch it in and get in the building without you, the receptionist, buzzing me in.
Right.
Thank you.
Okay. Thank you, Ms. Meadows. Next witness.
Again, that was the testimony of Gail Meadows, an administrative assistant that worked at the company of the victim, Diane McIver. And you just heard the jury question, two questions. One, why was she no longer working there? And two, about Tex McIver's ability to enter the building or not. I thought the defense attorney did a great job of explaining, you're talking about this event, you don't even know this guy. Carissa, what did you make of it?
I thought that the defense attorney did a very good job refocusing how anyone who has the code doesn't need permission to enter the building. For all we know, Diane McIver could have given her husband the code to go in the building real fast, to go do something for her real fast. And, you know, you heard from the witness, she has no personal relationship with Diane. She has no personal relationship with Mr. McIver. So anything she says is based on just her strict experience from that day of seeing him out of context, not used to seeing him, and commenting on it.
Carissa, stand by. I think we have another witness coming on the stand right now, and eager to hear what this next witness has to say. It's been a good day so far about hearing of the life of Diane and Tex McIver. Let's listen in.
Please state your name and spell. Terry Brown, Terry Brown.
Good morning, Mr. Brown.
Good morning.
Can you introduce yourself to the jury and tell them what you're doing for a living now?
I was the executive assistant at U.S. Enterprises, and I am currently unemployed. I was released from U.S. Enterprises January 31st of this year.
And let's talk about why you no longer work at the court company.
Well, with Diane being deceased, our CFO about 4 months later resigned, and those are basically the two people that I supported. So basically my job has been gone for about a year, and it just took them this long to terminate me.
And when did you start working at the court company, or U.S. Enterprises?
August 16th, 2010.
Okay. And so you worked there about 7.5 years?
Yes.
Now, while working there for the 7.5 years, can you tell the jury what your position as an executive assistant entailed?
Well, I supported the CFO and the president, which was Diane. I supported her professionally and personally. So I did whatever it is that she needed done to get through the day. was my role for her. And for the CFO, I did most of his business dealings, as well as they both owned outside businesses, and I helped them with those businesses as well.
And you said you worked with the CFO. Who was the CFO?
Oh, Richard Harrell.
And did you work as an executive assistant for anybody else in the building?
If Mr. Corey needed something, he would come to me from time to time. So I did do things for him as well, yes.
But primarily you worked with Ms. McIver?
Yes.
Now, you said you worked with her business, I guess, dealings, as well as you were her personal assistant.
Correct.
Why don't you tell the jury what you mean by being her personal assistant?
If there was an issue with anything at the house, either of the houses, she would call me and I would arrange to have whatever the issue was fixed. I mean, I ordered her clothes, I ordered her makeup, I ordered her coffee. I did everything for her except I did not pick up her laundry and I did not do her grocery shopping. Other than that, I pretty much supported everything that she needed throughout the day.
Previously shown to defense counsel and marked as State's Exhibit 201 through 206. You will look at those and tell me, see if you recognize them, and look up when you're done looking through them. Okay? Do you recognize State's Exhibit 201 through 206?
Yes.
Okay. And what are State's Exhibit 201 through 206?
These are the checkbook registers that I kept.
And are these the electronic checkbook registers or the Excel spreadsheets you just told the jury about?
Yes.
And do they appear to be a fair and accurate copy of the registers that you did each year for Ms. McIver?
Yes.
Your Honor, at this time the State would tender what's been marked as State's Exhibit 201 through 206.
No objection.
They're admitted.
Thank you, Judge. May I publish?
You may.
Now, Mr. Brown, we're not going to go through each one of your checkbook registers, but will you just explain to the jury, I guess, what they're looking at, and if this is what you did for each year, a month of each year, while you worked with Ms. McIver?
Yes.
Okay. And see where the top left-hand corner box, what's the label there?
That's her personal checking account,
Okay.
and the checking account number.
And is there a page in
Can you slide that off the screen for a minute?
Yes.
I don't know if that's a complete account number, or if that's still an active account
It's
number.
not. It's not.
Well, they're my answers. Okay, then you can put it back up. Let's just be mindful of that as we go forward.
Yes, Judge.
Thank you, Mr. Brown.
Mr. Brown, is there a page in each one of the Excel spreadsheets for all of her accounts?
Not her money market. I didn't track that. Okay. So you'll have one for her personal, which was Brand Bank. You'll have one for claim management, which is Brand Bank, and there should be one for claim management that is Bank of North Georgia.
So there's one for each one of the accounts?
Yeah, there's a check register for each account, yes.
Okay.
That's Terry Brown. He was the executive assistant of the victim in this case, Diane McIver. Again, we're talking about the Tex McIver case, a man who was charged with the shooting death of his wife, and he is claiming it was an accident. Now we're starting to hear about the life of Diane McIver, and who better than her personal assistant, which is something I feel like I need. Well, how about you, Carissa? Do you feel like you need one?
Yeah, and he's without a job, so maybe we should hire him.
Yeah, well, maybe. But you know what's good? It's interesting to hear about the different accounts that she has, and we're starting to get into the nitty-gritty of this. Where do you think the prosecution's going?
Well, I'm still waiting to hear what the smoking gun is of what he knows. Right now, they're building him up as someone who has a personal relationship with Diane McIver, someone who was intimately involved in the details of his life, the financial details of her life, and this is probably going to go to the state's case of motive of why Mr. McIver would want Mrs. McIver dead and why she was more valuable dead than alive. But yet we still haven't heard that evidence that would make that case. We're still listening. They're just right now building him up as someone who had access to all her accounts, created spreadsheets. His spreadsheets were so good that she chose to go with his spreadsheets rather than normal banking checkbooks to balance. And, he's someone that is now without a job, but who was her main right arm that did everything for her except grocery shopping and dry cleaning.
Yep.
So we've heard. So
let's listen in about what else he has to say.
But I always told everybody, because I knew these people also, so I didn't want them to get called from her. I would call them, so I always told her everything was fine. And it generally was always fine. I always got the money every month.
So you were persistent?
Yes.
Okay. Now, you said she loaned money to her friends. Who did she loan money to?
She had a loan to John Hahn, who is a U.S. Enterprise employee. She had a couple loans to Danny Carter. She had a loan to Tex. She had a loan to Ann Swall. She had a loan to James Hugh.
And are all of these people outside of the defendant close personal friends of Ms. McIver?
Yes.
And she charged her close personal friends interest?
Yes.
Okay. So her money was that important to her?
Objection, Your Honor. Argumentative.
Right. Sustained.
I'll withdraw the question.
Good choice.
And you said she made loans to the defendant, Mr.
Yes.
McIver. And did she expect Mr. McIver to pay her on time with interest?
His loan was interest only, so he only paid interest.
Okay.
He didn't pay any principal.
Now, you said his loan. Tell the jury a little bit about his loan and what the loan was for.
The loan was for $350,000. I'm not sure what the loan was, what the money was given to him for. It started January 15th of 2012, and he made interest-only payments. It was a 3-year term originally, and the payments were $1,531 a month. And at the end of the 3 years, Diane came to me, it was January, I guess, of 15, to say, I've re-upped the loan for another 3 years, and I've reduced his payment to $1,400 and something dollars.
Okay. So let's backtrack for a second.
And there's a spreadsheet for all of that also.
Okay. And is it in State Exhibits 201 through 206 that you looked at earlier? Or would it be in that?
It wouldn't be in the checkbook registers. It was a whole, I had a file for each person that had a loan out, and each month it had the amount of the payment, and then I posted the payments as they were being made.
Okay.
So there is a spreadsheet for that someplace.
So you said that the loan was for $350K?
Yes.
And it was how many years?
The original was 3.
Okay. And that started when?
January 15th. The payment was due on the 18th of the month, and it started in January. I think it was 2012.
And it was 3 years from there.
Yeah, and it was $1,500 and some change a month.
And then you said that loan was renewed?
It was renewed in, I guess, 2015.
Why was it renewed?
I have no idea. I was just told it was renewed, and the payment was reduced to $1,400 and change. And I don't know why it was reduced.
How would you describe Mr. and Mrs. McIver's marriage?
As far as I can tell you, it was a very good marriage.
And did you plan vacations for them?
Yes.
Okay. When you planned those vacations, was it just for the two of them, or did other people go?
There was generally always someone with them on vacation.
I'm sorry, the last part trailed off.
Oh, there was generally somebody always. An example, they took the Swalls on vacation once a year. They did golf trips, and they usually traveled with friends from Canada, or they traveled with friends that live here that golfed. You know, so they were generally golfing vacations when they traveled, unless they were going with the Swalls, and then that was just a family vacation. And I planned it all, down to the tea times, cars to take them to dinner, where they were having lunch, what time breakfast was going to be. There was an itinerary done. The woman never rested. I mean, literally, it was supposed to be vacation that was every minute was scheduled from when she got up in the morning till she went to bed at night.
Okay.
And that was vacation.
So she liked to fit a lot in 24 hours?
Yes.
Okay. Do you remember telling me that they were never alone?
Very rarely were they ever alone that I know of.
Explain to the jury what you mean by that.
Well, even when they always had a group of people with them, and I guess that's how they liked. That's what they liked. They just didn't spend. There was always people at the condo. There was always people at the ranch. There was always people around them.
Now, I'm going to put this demonstrative back up. Can you show the jury, Your Honor, permission for Mr. Brown to step down?
Sure, Mr. Brown, you may need to get up so you can point things out on whatever that big board is. And Ms. Clark-Palmer, you're free to move where you need to see it.
Can you show the jury where in this diagram of the inside of U.S. Enterprises your office was, or your area was?
Can you all see that? I don't know. It's at a funny angle for folks way against the wall. Should we move it, or is everyone good? Swing it out a little bit. Great. That'll make it easier for Ms. Clark-Palmer to see as well.
Better? Okay. So you were up towards the middle.
Again, this is Terry Brown, the personal executive assistant of Diane McIver, going through her life, her finances, her relationship with Tex McIver, and her godson, Austin. Let's talk a little bit about this with Carissa. You're seeing him talk about this. They always wanted people around. They had a good life. What am I supposed to gain from this if I'm a juror?
I don't think we've heard. This is the state's witness right now, so there is obviously some information that the state wants the jury to hear to imply some type of culpability.
And Carissa, stand by. I think he's about to talk about the file cabinet, so
Right.
let's listen in.